Hello and welcome back to Ganga Education. On this platform, you will find quality lectures relating to the field of law, competitive examination in legal domain, important legal facts and legal history, all explained in clear and structured manner. In this video, we are going to discuss Bharatiya Sakshya Adhiniyam 2023 from section 66 to 73.
Today, we're going to break down a very important topic, Section 66 of the Bharatiya Sakshya Adhiniyam 2023. Now, this section is all about how you prove electronic signatures in a court of law. And let me tell you, for your judiciary and APO exams, this is absolutely critical information. So, to make sure this is all crystal clear, we've broken our discussion down into 6 main parts. We'll start with the basic rule itself. Then we'll explain some key terms you need to know. After that, we'll look at a really important exception. We'll cover how you actually prove these signatures, look at some landmark court cases, and finally, we'll wrap it all up with a sharp focus on what you need to remember for your exams.
All right, let's jump right into the first part. What is the core principle that Section 66 lays down when it comes to proving electronic signatures in court?
So this is the section we're focusing on today. Notice where it's located, Chapter V, which is all about documentary evidence. Now, why is this important? Well, its placement is really crucial because it tells us that electronic proof is now formally part of the traditional framework of evidence law. That's a key concept you'll want to remember for your exams. So, what does all that legal language actually mean? Well, in simple terms, it's this. If you walk into court with an electronic document, say an e-contract, and you claim that a specific person signed it, the responsibility, the burden of proof is on you. You're the one who has to prove to the court that the signature really belongs to that person. Okay, to fully understand this section, we've got to break down some of the key terms. Let's take a closer look at the exact words the law uses. First up, electronic signature. And this is a really important point. It's not just your handwritten signature that you scanned and pasted onto a document. No, it's a specific digital method, something that uses technology like cryptographic keys or a digital certificate. Its purpose is twofold, to authenticate the document and to confirm who actually signed it. Next, we have the term subscriber. So who is a subscriber? Simply put, a subscriber is the person who owns or controls that electronic signature. Think of them as the authorized user, the one whose name is on the digital certificate. So let's put it all together. You've got 3 main pieces to this puzzle. There's the subscriber, who is the person. There's their electronic signature, which is the digital tool they use, and there's the electronic record, which is the document itself. Understanding how these 3 things connect is absolutely fundamental to this section. Now, this is where things get really interesting. Section 66 has a very critical exception. The law basically carves out a special category where that standard rule we just talked about, the one about having to prove the signature, well, it doesn't apply. This is a huge distinction, so pay close attention. And this slide shows you the core difference perfectly. For a standard electronic signature, you have to prove it's real. But for a secure electronic signature, it's the other way around. The court automatically presumes it's authentic. This flips the burden of proof completely. Suddenly, it's not on you to prove it's valid, it's on the other party to prove it's invalid. Why? Because the law has a higher degree of trust in the technology behind these secure signatures. So that leads us to a pretty logical question, right? If a signature isn't a secure one, and you have to prove it, how exactly do you do that in court? What are the methods the law recognizes?
Well, the law gives you a few different ways to do it. For one, you can present the digital signature certificate, which comes from a recognized certifying authority. Another option is to bring in a technical expert who can verify the cryptographic keys and the tech side of things. And of course, there's the most straightforward way. The person who actually signed the document can just admit to it in court.
Okay, so we've looked at the law itself, but how have the courts, especially the Supreme Court, actually interpreted all of this? Let's dive into 2 landmark judgments that are absolute must-knows for your exams. The first case, and honestly probably the most foundational one in this entire area, is Anwar PV versus PK Bashir. This is the judgment that really set the ground rules for how electronic records are treated as evidence in India. So what did the Supreme Court say here? They made it very clear that for any electronic record to be allowed in court, you must follow the statutory requirements. We're talking specifically about the certification process laid out in the Evidence Act. The court said this is mandatory, not just a suggestion. And they also clarified that these special rules for electronic evidence take precedence over the general rules of evidence. All right, the second key case you need to know is Arjun Pandikar Kolkar versus Kailash Kushanal Gorantio. Now, this case is important because it builds on the foundation laid by Anvar PV and gets into even more detail about the specific procedures you need to follow. In this judgment, the court doubled down on the idea that the certificate is a condition precedent. What does that mean? It means you have to have it before the electronic record can even be considered admissible evidence. The court then went on to provide really detailed guidelines on how and when this certificate should be produced, which helped create a much more uniform procedure for courts everywhere. Okay, let's switch gears a bit and consolidate all of this from a pure exam point of view. What are the absolute key takeaways you need to have locked in for your judiciary and APO exams? First things first, you need to know the old law versus the new law. This rule used to be in Section 67A of the old Indian Evidence Act of 1872. Now, under the new Bharatiya Sakshya Adhiniyam 2023, it's Section 66. That's a classic prelims question right there, so make a note of that change. Now, for your exams, here's what to expect. In the prelims, you're likely to see a direct question on the section number, Section 66, and almost certainly something about that secure signature exception. For the mains, you need to be ready for either a short note on proof of electronic signature or maybe even a problem-based question, perhaps involving a dispute over an e-contract. And the most critical concept to have mastered for that is the difference in the burden of proof. All right, for super quick revision, just lock in these 3 points. 1, the section number is 66. 2, the core rule is that you must prove the signature. And 3, the huge exception is for secure electronic signatures, where you don't have to prove it unless it's challenged. Got it? Section 66, mandatory proof, secure exception. For more legal content focused specifically on judiciary, APO, and other law exams, make sure you stay connected with us here at Ganga Education.
I am Assistant Professor Dhanashri Yogesh Kadam. For your judiciary and APO exams, Section 67 of the Bharatiya Sakshya Adhiniyam 2023 is an incredibly important section, so let's get right into it.
Just think about it for a second. When a document that could literally change a person's life is put before a judge, how can we be sure it's the real deal and not some clever fake? Well, that's the exact problem that Section 67 is here to solve.
So here's our roadmap. We'll kick things off with an introduction to Section 67, then we'll break down the main rule. After that, we'll see how it all works in court, look at a really important exception, and finish up with a sharp focus on what you need for your exams. Today we are discussing Section 67 of the Bharatiya Sakshya Adhiniyam 2023. This section deals with the specific procedure for proving attested documents in court. You could say it's the bedrock for verifying some of the most critical legal documents before they can ever be considered as evidence.
Now, before we go any deeper, let's get one key term straight: attestation. What does it mean? It's simply the formal act where a witness physically watches the main person, we call them the executant, sign a document, and then that witness adds their own signature. That signature is their testimony, saying, yes, I saw this happen.
Okay, so with that idea of attestation in mind, let's now look at the core legal rule that's laid out in Section 67.
Okay, so the Bare Act says that if the law requires a document to be attested, it's basically useless as evidence until at least one of those attesting witnesses is brought to court to prove it was signed correctly. In simple language, अगर कानून के अनुसार किसी डॉक्यूमेंट पर विटनेस के साइन जरूरी हैं, तो उस डॉक्यूमेंट को एविडेंस मानने से कम एक विटनेस को कोर्ट में बुलाना पड़ेगा. Now, of course, that's assuming the witness is alive, can be found, and is fit to give evidence.
This section really boils down to 3 important elements. First, you have the attesting witness. That's the person who physically saw the signing and then signed themselves. Second, you have execution. This is the whole act of signing that breathes legal life into the document. And third, required by law. This isn't for every document, but for specific high-stakes ones like wills, mortgages, and gift deeds.
So how does this rule actually work inside a courtroom? Let's trace the journey of a document from just being a piece of paper to becoming accepted, solid proof.
It's a very logical sequence. You start with a document, like a will, that needs to be attested. It's then presented to the court. Now, the person who is relying on that will must call at least one of the original witnesses to the witness box. That witness then testifies under oath that they saw the person making the will sign it, and only after that testimony does the will get admitted as formal evidence.
Let's make this really concrete with a practical example you might see in your exams. Suppose एक situation लेते हैं. Let's imagine a heated family dispute over whether a will is genuine or not. This happens all the time.
So in our scenario, a relative is screaming forgery. The core legal question for the judge is, was this will executed validly? And Section 67 gives us the answer. The person who wants the court to accept the will, we call them the propounder, has the burden of proof. It's their job to bring one of those original attesting witnesses to court to say, yes, I saw the deceased sign this will. If they can't do that, the will fails.
And believe me, the Supreme Court takes this very seriously. The court has said time and again that it must be completely satisfied, that its conscience must be clear, that the will was signed correctly and, just as importantly, without any force or fraud. This is not just a box-ticking exercise. It's about getting to the truth.
A perfect example of this is the landmark case of H. Venkatachala Iyengar versus B.N. Thimajama. Here the Supreme Court laid it all out. It held that the person putting the will forward must clear away all suspicious circumstances. And the number one way to do that is by calling an attesting witness to satisfy the court's conscience that everything is above board.
Now, as with so many rules in law, there's a very important exception to Section 67. This is found in the proviso, and you absolutely have to know this for your exams.
So, look at the contrast here. The general rule says you must call a witness. Simple. But the exception says that if the document is officially registered, then you don't need to call a witness. But, and this is the key part, this only applies if it's a registered document and, crucially, if it is not a will.
Let's be absolutely clear about the conditions for this exception. 1. The document, say a gift deed, must be registered. 2. It cannot be a will. 3. The other side isn't in court actively denying that the signature is theirs. If they deny it, you're back to the main rule and you have to call the witness. And let me say it one more time because it is that important. This exception never, ever, ever applies to wills. A will must always be proven by an attesting witness, even if it's registered.
Okay, let's bring it all home and focus on exactly what you need to remember for your exams. These are the key takeaways for every aspirant.
So why do we even have this rule? It's not just a technicality. For your mains answers, remember this. Section 67 is a guardian. It ensures authenticity, it prevents fraud, it provides the court with reliable evidence, and it protects innocent parties from being cheated by fakes. It strengthens the very foundation of evidence.
Now, for those of you who have studied the old law, this principle will sound very familiar. Ye provision Pele Indian Evidence Act of 1872 ke Section 68 mitha. Now it's been placed in Section 67 of the new Bharatiya Sakshya Adhiniyam 2023. The fundamental rule is still the same.
And here's a direct tip for your exam prep. In the prelims, you can expect a direct question on this section. For your mains, be ready for a problem-based question, most likely a scenario involving a will dispute, where you'll need to apply Section 67's principles to solve it.
All right, for a quick revision, just lock these three things in your mind. First, the section number, Section 67. Second, the core concept. An attested document must be proven by calling at least one attesting witness. And third, the key exception. This rule doesn't apply to registered documents unless it's a will or the execution is being denied. It does make you think, doesn't it? Is the law's extra strict rule for wills still justified today? For more judiciary, APO, and law exam-focused legal content, stay connected with Ganga Education.
Today, we're diving deep into Section 68 of the Bharatiya Sakshya Adhiniyam 2023. Now, this section answers a really interesting question. What happens when you need to prove a document in court, but you just can't find the original witnesses? This is a super important topic, especially for your judiciary and APO exams, so let's get straight into it.
So let's imagine a situation. You've drafted a will. You've done everything by the book. You even have witnesses sign it. But years later, when it's time for court proceedings, those witnesses are simply gone. What do you do? Does that mean the will is now worthless? Well, not at all. And Section 68 is exactly what gives us the solution. So here's our game plan for today. We'll start with what Section 68 is all about. It's a crucial exception. Then we'll see exactly when it kicks in. After that, we'll look at the simple two-step method to prove the document, check out what our courts have said about it, see how it's changed from the old law, and finally, we'll wrap up with some solid exam tips. Okay, so normally for certain documents like wills or gift deeds, the law is very strict. It says you must call at least one of the attesting witnesses to court to prove it. That's the main rule. But what Section 68 does is it carves out a very, very important exception to this rule. Now, let's look at the actual text from the Bear Act. It might sound a bit technical, but it's actually quite simple. All it's saying is this: if you can't find any of the witnesses,
Don't worry, you can still prove the document is legit. You just need to prove two things. First, that the signature of at least one of those witnesses is real, and second, that the signature of the person who made the document is also real. That's it.
So, this brings up a really important question. What does the law actually mean when it says no attesting witness can be found? I mean, what kind of situations are we talking about here?
Well, the law is pretty practical here. A witness is considered not found in a few common sense scenarios. For instance, if the witness has unfortunately passed away. Or maybe you just can't find them. They're untraceable. It also applies if they've become incapable of giving evidence, say due to a severe illness. And finally, if the witness is living abroad outside the court's jurisdiction, or if you've tried everything and still can't get him to court, Section 68 comes to your rescue.
Okay, so we've established that the witness is unavailable. Now what? How exactly do you go about proving the document? Thankfully, the law doesn't leave us hanging. It gives us a very clear two-step method to follow. So, what are these two simple steps?
The process is actually surprisingly straightforward. There are just two boxes you need to tick. Step 1, you have to prove that the signature of at least one of the attesting witnesses is genuine, that it's really their handwriting. And Step 2, you have to prove that the signature of the person who actually created the document, we call them the executant, is also genuine. If you can prove both these things, the court will consider the document proven.
Let's make this crystal clear with a practical example that you'll see all the time in court: proving a will. Problem-based questions on wills are a favorite in exams, so this will really help you understand how the section works in the real world.
This scenario explains it perfectly. So, the situation is that a will was made and it was signed by two witnesses just as required. But the problem is, by the time the case comes to court, both of those witnesses have passed away. So, what's the solution? Well, under Section 68, the person trying to prove the will just has to do two things: prove the handwriting of one of those deceased witnesses, and prove the signature of the person who made the will, the testator.
Now, to truly grasp any legal provision, we have to see how our courts have applied it over the years. So let's take a look at a couple of landmark judgments that have really shaped our understanding of this principle, which is now in Section 68. The first case is a very important one from the Supreme Court, Benga Behera versus Braja Kishorenanda. In this case, the court held very clearly that if you can't bring an attesting witness to court, you can still prove the document was properly executed by proving the handwriting of both the witness and the person who signed it. This judgment directly reinforces the two-step method we just talked about.
And building on that, we have another key case: Janki Narayan Boyer versus Narayan Namdeo Kadam. Here the court emphasized something crucial. They said that proving attestation is absolutely mandatory. But, and this is the key part, when witnesses are unavailable, the alternative methods that the law provides, like the one in Section 68, can and absolutely should be used.
So you might be wondering, is this a brand new provision, or did it exist before? Well, this concept isn't new at all. It's actually a time-tested principle that has been carried forward from the old evidence law.
Now, this is a very important point for your exam, so make a note of this. Under the old Indian Evidence Act of 1872, this rule was found in Section 69, but in the new Bharatiya Sakshya Adhiniyam of 2023, it is now Section 68. So remember, the section number has changed from 69 to 68.
All right, let's get down to brass tacks. Why is this section so critical for your judiciary and APO exams? And, more importantly, what kind of questions can you actually expect from this topic? Okay, for your prelims, you could get a very direct question. They might ask for the section number or ask what needs to be proven if a witness isn't found. But for your mains exam, it gets a bit more challenging. You could be asked to write a short note, or what's even more likely, they'll give you a problem-based question, just like that will example we discussed, and you'll have to apply Section 68 to solve it.
Okay, before we finish, let's do a really quick revision to make sure all these important points stick in your mind.
So if you take away only 3 things from today, let it be these. First, the section number. We're talking about Section 68 of the Bharatiya Sakshya Adhiniyam. Second, the core concept. If your witness is missing, you prove the document by proving the witness's handwriting and the executant's signature. And third, exam importance. This is a high-yield topic for both your prelims and your mains.
So as you can see, Section 68 offers a really vital and practical solution in evidence law. It makes sure that important documents don't just become useless because of circumstances beyond our control. For more in-depth explainers like this, focused on judiciary, APO, and other law exams, make sure you stay connected with us here at Ganga Education.
I'm Dhanashri Yogesh Kadam, and today we're going to dive into a really crucial piece of evidence law, one that can often be a complete game changer in a civil case. Today, our focus is on Section 69 of the new Bharatiya Sakshya Adhiniyam 2023. This section deals with a fascinating and very practical question. What happens when the person who actually signed an official document admits to doing so in court? It's a fundamental rule of evidence, and trust me, understanding it is absolutely essential if you're preparing for the Judiciary or APO exams. So here's how we're going to break it all down. We'll start with a basic introduction, then we'll deconstruct its core ingredients to see how it really works. After that, we'll look at some real-world examples and how courts have interpreted this rule. We'll also connect it to the wider legal landscape. And finally, we'll wrap up with the key takeaways you need for your exams. Ready? Let's get started. All right, first things first, let's introduce this section. What is the fundamental rule that Section 69 really establishes? The BSA Act states that the admission by a party to an attested document of its execution by himself shall be sufficient proof. So what does that mean in simple English? Well, it means that if a person who created a legal document actually admits in court, yes, I signed this, the court can take that statement as sufficient proof against them. Basically, their own words become the evidence. It's as simple as that. Okay, so we've got the basic rule down. Now, let's break it down further. What are the core ingredients that really make this section tick? You'll see there are three key elements here. First up, the party to an attested document. Now, that's just a way of saying the person who actually created and signed the document, we call them the executant. Second is the admission of its execution. This is that critical moment where the executant says, yes, that is my signature. And third is the legal consequence, sufficient proof. The court now has what it needs to consider the document proven, at least against the person who made that admission. So you can almost see the checklist the court goes through, right? It starts with the executant, the person who made the document. Then they make that crucial admission of signing it. This leads directly to the result. The document is now considered sufficient proof against them. And here's the kicker. The most important practical effect of this whole process is that there's no longer any need to call the attesting witnesses to prove the signature. The admission does the job all on its own. But let's be clear, what do we mean by a legal admission here? Well, an admission is really just a statement where a party acknowledges a fact. In our case, it's the simple act of accepting that you signed the document. Now, this can happen formally, maybe in the written pleadings filed in court, or it can happen orally during an examination, right there in the witness box. And believe me, once that admission is on the record, it sets off a chain of really significant legal effects. First, like we said, the court doesn't need to examine the attesting witnesses. This can save a massive amount of time. Second, the document is then treated as proven against the person who admitted it. This, in turn, significantly reduces the burden of proof for the other side. But, and this is a really crucial point to remember, this admission is only binding against the person who makes it, not against anyone else in the case. Okay, that's the theory, but how does this actually play out in a real courtroom? Let's look at a practical scenario to see Section 69 in action. All right, picture this. It's a very common situation. A person takes out a loan and executes a mortgage deed as security. Down the line, there's a dispute over repayment, and the case ends up in court. Now, during the trial, the bank's lawyer asks the person, "Is this your signature on the mortgage deed?" And the person replies, "Yes, it is." In that one moment, boom, Section 69 kicks in. The bank no longer has the burden of bringing in the attesting witnesses to prove the document. The person's own admission is all the proof needed against them. Of course, a section is just words on a page until the courts interpret it. So to really get a grip on the power of Section 69, we absolutely have to look at some landmark judgments that have defined how it's applied. A key case to know is Narayan Bhagwantrao Gosavi versus Gopal Vinayak Gosavi. So in this case, the big question before the Supreme Court was this: can a simple admission completely replace the need for formal technical proof? And the court's answer was a resounding yes. It held that admissions aren't just procedural shortcuts, they are substantive evidence. A clear admission eliminates the need to prove the document through other, more complicated means. And you can see the power in the court's own words. Admissions are substantive evidence, and a clear admission of execution can dispense with formal proof. This is a fantastic line to remember, especially for your mains answers. It really sums up the whole idea perfectly. Now, let's look at another important case, Avad Kishore Das versus Ram Gopal. This one really dug into the evidentiary value of that admission. The court confirmed that an admission by the person who signed the document is sufficient evidence against them. It's considered rock-solid evidence unless that person can successfully explain it away or, formally take it back with a valid legal reason.
Okay, we've been really zoomed in on this section itself. Let's pull back for a moment and see how Section 69 fits into the bigger legal picture and some foundational principles.
There's actually a classic Latin legal maxim that perfectly captures this whole idea. Confessio in judicio omni probatione major est. It basically means that a confession or admission made right there in court is more powerful than any other kind of proof. You can see how Section 69 is pretty much a direct application of this ancient legal wisdom. Now, for those of you who've been studying the older laws, this whole concept might be ringing a bell. And you'd be right. This rule used to be Section 70 in the old Indian Evidence Act of 1872. It has now been brought into the new Bharatiya Sakshya Adhiniyam as Section 69. So the number changed, but the core legal principle, that has not changed at all. And listen, here's a very important point, especially for your exams. Section 69 is a rule of evidence. It's procedural. It tells the court how to prove a document. It doesn't define a crime, and it certainly doesn't come with any punishment. It's all about process, not penalty. All right, we've covered a lot of ground. Now let's get to what is probably the most important part for all of you studying for exams, the key takeaways. So, when it comes to your exams, here's how you should prepare for this section. For your prelims, expect a direct question, maybe asking for the section number or its core principle. For your APO and Judiciary mains, be ready for two possibilities, either a short note explaining Section 69, or more likely, a problem-based question involving a document like a will or a mortgage deed where this principle is key. Okay, before we finish up, let's do a super quick revision. If you remember nothing else, remember these three things. First, the section number, Section 69 of the Bharatiya Sakshya Adhiniyam. Second, the core concept. An admission by the executant is sufficient proof against them. And third, its exam importance. This is a high-priority topic for both your prelims and your mains. So what's the ultimate takeaway from all of this? Perhaps it's a simple but profound truth. In the eyes of the law, sometimes a person's own word is the most powerful evidence of all. For more deep dives into content like this, all focused on Judiciary, APO, and other law exams, make sure you stay connected with us here at Ganga Education.
Today we're diving into a really important section, Section 70 of the brand new Bharatiya Sakshya Adhiniyam 2023. Now, this one is absolutely crucial for your Judiciary and APO exams because, let's be real, it deals with a problem that pops up in our courtrooms all the time. All right, let me paint a picture for you. Imagine you're in court. A will is presented. But then, the attesting witness, the one person who is supposed to confirm it's genuine, gets on the stand and says, "Nope, I didn't sign that." Or maybe just, "Honestly, I can't remember." So what now? Is that will, someone's last wishes, just invalid? Let's find out what the law says. Well, the answer to that tricky situation lies right here, in Section 70 of the Bharatiya Sakshya Adhiniyam 2023. You'll find it in Chapter 5, which deals with documentary evidence. This section is our roadmap for proving a document when the main witness just isn't cooperating. So here's what we'll cover today. We'll start with an introduction to Section 70, break it down, see it in action, look at its legal context, and then wrap up with a sharp focus on what you need for your exams. Let's get started. Okay, so there are certain documents, like wills, mortgages, gift deeds, that absolutely must be attested by witnesses, right? It's all about making sure they're authentic. To prove them in court, you have to call at least one of those witnesses. But here's the problem. What if that witness turns hostile? Or what if they just flat out deny signing it? That's exactly where Section 70 steps in. It's the legal fix for this exact situation.
Let's read the BEAR Act itself. It's quite straightforward. It says, if the attesting witness denies or does not recollect the execution of the document, its execution may be proved by other evidence. So in simple words, the fate of a perfectly good document doesn't rest on just one person who might be unreliable or forgetful. The law gives you another way, a plan B, to prove it.
All right, let's dig a little deeper into this section. We're going to break it down to see what its key parts are and what's really trying to achieve. This will help us understand exactly how it works.
So Section 70 really kicks in under two specific conditions. First, when the witness straight up denies it. They could be hostile, maybe they've been pressured, who knows. And second, when the witness just says, "I don't remember." And that's fair, right? A lot of time can pass. In either of these cases, boom, the door to Section 70 swings right open.
Now, the key phrase here is other evidence. But what does that actually mean? Well, it's not just one thing, it's a whole toolkit of options.
For instance, you could bring in someone to prove the handwriting or signature of the person who made the document. You could also present circumstantial evidence, facts about what was happening around that time. Or you could call a handwriting expert to give their professional opinion. And hey, if someone else was in the room when it was signed, their testimony works too.
So what's the big idea behind this section? What's its purpose? It's pretty simple, really. It's a safety net. It makes sure that justice doesn't fail just because of one hostile or forgetful witness. Think about it. If everything depended on that one person, a single dishonest witness could destroy a valid document. Section 70 is there to make sure that just doesn't happen.
Okay, we've got the theory down. Now let's move from the books to the courtroom. How does Section 70 actually work in practice? This is where it gets interesting.
The whole process is really logical. Let's walk through it. Step 1, you have a document that legally needs to be attested. Step 2, you call the attesting witness, but they deny it or say they forgot. And that brings us to Step 3. The court then allows you to bring in that other evidence we just talked about to prove your case.
Let's use a classic example, the kind you might see in your exams. A will is up for probate. The only attesting witness available takes the stand and says, "Sorry, I just don't remember this." Is the case over? Absolutely not. Thanks to Section 70, the person trying to prove the will can now call someone else, maybe a relative or even a banker who knew the deceased signature well, to come and verify it. See how that works?
All right, to get the full picture, we need to see how Section 70 fits into the bigger legal world. We'll look at some important case law and see how this section works alongside other related provisions in the Act.
Okay, there's one landmark judgment you absolutely have to know for this topic. It's the Supreme Court case Janki Narayan Boyer versus Narayan Namdeo Kadam.
This case really hits the nail on the head. The Supreme Court said, and I quote, "When an attesting witness fails to prove execution, the party relying on the document may prove it through other evidence permitted by law." It's a direct confirmation, a judicial stamp of approval on the very principle of Section 70.
So just to make it easy for you to remember, let's quickly recap the principles from two key cases. In Janki Narayan Boy, the takeaway is clear. If the attesting witness fails, you can use other evidence. And in Benga Behera versus Braja Kishore Nanda, the court reinforced that this applies even if the witness becomes hostile. It's all about providing that alternative route to proof.
Now, for those of you familiar with the old Evidence Act, this is a key point. This same rule used to be in Section 71 of the Indian Evidence Act 1872. Under the new Bharatiya Sakshya Adhiniyam of 2023, it's now Section 70. The rule itself hasn't changed at all, just the number, so don't get confused.
It's also helpful to see that Section 70 isn't alone. It's part of a family of sections that deal with proving attested documents. You've got Sections 67, 68, and 69, which all cover different scenarios. Think of Section 70 as the specific tool you use when your main tool, the attesting witness, doesn't work. All right, let's bring it all together and focus on what really matters for your exams. For all you Judiciary and APO aspirants, this is the key takeaway part.
Okay, some quick tips for your exams. In your prelims, you'll likely see a direct question about what Section 70 says. Simple. For your mains, be prepared for a problem-based question. A classic scenario is a will case where the witness turns hostile. You need to know how to apply this section. And please, remember the two magic words, denies and does not recollect. Those are the triggers.
All right, time for a super quick revision. 3 things to burn into your memory. 1. The section is 70 of the Bharatiya Sakshya Adhiniyam 2023. 2. The core idea is you can use other evidence if the witness denies or forgets. 3. This is a high importance topic for both prelims and mains. Got it?
And that's a wrap on our deep dive into Section 70. I really hope this breakdown helps you in your exam prep. For more content like this, all focused on Judiciary, APO, and other law exams, make sure you stay connected with us right here at Ganga Education.
Oh, there's so many yummy vegetarian options out there. You could try like lentil soup, veggie burgers, tofu stir fry. The possibilities are endless. Hello, and welcome back. Today, we are diving into a really practical and quite important part of evidence law, Section 71 of the new Bharatiya Sakshya Adhiniyam. We're going to break it all down. First, we'll introduce the basics, then we'll deconstruct the rule itself, look at how you actually prove these documents in court, and see it in action with some real cases. We'll also see how it compares to the old law, and finally, we'll wrap it all up with some key tips for your exams. All right, let's get right to the heart of Section 71. What's it all about? Well, it deals with a situation you will definitely come across, documents that have been voluntarily attested. You'll want to pay close attention here because this is a favorite topic for preliminary exams, and really understanding its core principle is absolutely key. So let's get into the specifics. We are discussing Section 71 of the Bharatiya Sakshya Adhiniyam 2023. This section is all about proving documents that have been attested, but voluntarily. Now, for anyone preparing for the Judiciary or APO exams, this is crucial. Why? Because it's about the procedural details that can genuinely make or break a case in court. So what does the BEAR Act actually say? It's beautifully simple and direct. It reads, an attested document, not required by law to be attested, may be proved as if it was unattested. Okay, let's translate that. In simple terms, what it means is this. If a document has witness signatures on it, but the law doesn't actually demand that type of document to be witnessed, then you can prove it in court just as if those witness signatures weren't even there. Okay, so we've read the letter of the law. But to truly master Section 71, we need to deconstruct it. Break it down into its essential parts. This will show us exactly when this rule kicks in and how it works. Look at how this table just simplifies the whole thing. There are really three important elements here. First, the document is attested by witnesses, meaning yes, witnesses have signed it. Second, and this is the key, this attestation was not required by law. It was a voluntary act, not a legal mandate. And third, because of those two facts, it can be proved as if unattested. The biggest takeaway, you are not required to call those witnesses to court to prove the document. So this brings up a very practical question, right? If we don't need to call the attesting witnesses, then how exactly do we prove such a document in court? Let's look at the standard methods that are available to a lawyer. Well, the process is actually pretty straightforward. Since the law lets you treat this document as if it were unattested, you can fall back on all the usual methods of proof. The most common way, of course, is simply proving the signature of the person who created or signed the document. Even better, if the other party just admits to signing it, well, your job is done. But you can also bring in handwriting experts or use the oral testimony of someone who saw it being signed, or even rely on circumstantial evidence. The main point here is flexibility and efficiency. This section gives you the tools to keep the judicial process moving smoothly. Theory is one thing, but how does all this work in the real world? And more importantly, what has the Supreme Court had to say about it? Let's walk through a practical example and some landmark cases to really solidify our understanding. Let's imagine a common scenario. A takes a loan from B, and they sign a simple loan agreement. Now, just to be extra careful, they ask two friends, C and D, to also sign the document as witnesses. Here's the thing. Under Indian law, a simple loan agreement doesn't need to be attested. So if a dispute comes up later, B can prove the document in court just by proving A's signature. He doesn't have to go through the hassle of finding C and D and bringing them to court to testify. This is a perfect illustration of the practical power of Section 71. And listen, this isn't just theory. The Supreme Court has put its stamp on this. In the landmark case of Kumar Harish Chandra Singh Dio versus Bansidir Mohanty, the court made it crystal clear. It said that just because witness signatures are on a document, you aren't bound by any special rules of proof, unless the law specifically demanded attestation for that document in the first place. And to really drive the point home, in another case, Sait Taraji Kimchand versus Yelamarti Satyam, the Supreme Court reinforced this principle. It held that the mere act of attesting a document is irrelevant to the method of proof. What really matters is the legal requirement. If the law doesn't say you must attest this, then the presence of a witness signature is, legally speaking, just an extra detail, not a procedural burden. Now, for a complete understanding, especially for those of you who have studied the old laws, it's always important to know where a provision comes from. So let's take a quick look at its legislative history. It's very simple. This provision was earlier found in Section 72 of the old Indian Evidence Act of 1872. Now it has been replaced and renumbered as Section 71 under the new Bharatiya Sakshya Adhiniyam 2023. The substance of the rule, the core idea, remains exactly the same, only the section number has changed. All right, let's boil all of this down to what really matters for your Judiciary and APO exams. This is the part where you'll want to take notes and really lock in these key points for your preparation. Whenever you study any section of the law, you should always ask, why? Why does this exist? Well, the purpose of Section 71 is simple: to promote judicial efficiency. It prevents unnecessary procedural roadblocks and delays in trials. I mean, can you imagine if every simple contract that happened to have a witness's signature required that witness to be found and brought to court? It would completely clog up the system. This section prevents that exact problem.
So for a quick revision, there are just 3 things I want you to remember. First, the section number, Section 71 of the BSA 2023. Second, the core concept, which is that voluntary attestation does not change the method of proof. And third, its exam importance is high. You can expect a direct question in your prelims, and it's very relevant for procedural questions in your mains exam. For more judiciary, APO, and law exam-focused legal content, stay connected with Ganga Education.
In today's session, we're going to be decoding a really important provision from the new evidence law, one that's absolutely crucial for your upcoming judiciary and APO exams.
So आज हम डिस्कस करेंगे सेक्शन 72 of the Bharatiya Sakshya Adhiniyam 2023. At its core, this section is all about how we prove that a document is authentic. Understanding its little details is critical because it really forms the foundation of how our courts verify any disputed document.
So here's what we've got planned for this explainer. We'll start with the basics of Section 72, then we'll break it down into its key parts. After that, we'll see how it works in the real world with a practical example, look at some major case laws, and finally wrap up with some exam tips and a quick revision. So let's get started.
All right, so first things first, what is the main job of Section 72?
Well, you can think of it as a tool, a very logical mechanism that the court uses to settle fights over whether a document is genuine or not.
Essentially, जब भी कोर्ट में किसी डॉक्यूमेंट पर दिए गए सिग्नेचर, हैंडराइटिंग या सील की जेन्युइननेस पर सवाल उठता है, this section jumps into action. It gives the judge a really practical, almost scientific way to figure out the truth by simply comparing the item in question with another sample that everyone agrees is authentic. Let's have a quick look at the actual words from the BEAR Act. Now, what's really important here is how wide this power of comparison is. Simple language में समझें तो इसका मतलब है कि if a court needs to check a signature, it can take any other signature of that person that's already been proven to be real and use it for comparison. It doesn't even matter why that other signature was submitted in the first place.
Okay, now that we have the big picture, let's zoom in a little. We're going to break this section down into its most important parts. Really understanding these keywords is key to writing a great answer in your mains exam. This section is mainly concerned with these 4 things. First, we have signature. That's your basic mark to say, I approve this. Second, handwriting, which is all about a person's unique writing style. Third is the seal, like an official stamp. And finally, finger impression. And it's so important to remember that subsection 3 makes it very clear that this whole comparison rule also applies to finger impressions. So how does this all work in a courtroom? Well, it follows a very simple logical flow. Step 1, a document with a questionable signature or writing is brought before the court. Step 2, the court compares that questionable sample with one that is known to be genuine. And finally, step 3, based on that comparison, the court makes a decision on whether the document is authentic or not. It's a beautiful, straightforward procedure. All right, enough with the theory. Let's get practical. Understanding how this section actually works in a real court case is so important, especially when you're trying to solve those tricky problem-based questions in your mains exam. Now, this section gives the court some pretty significant powers. The judge can, on their own, decide to examine and compare the writings. But here's the real kicker. This comes from subsection 2. The court can order any person who is right there in the courtroom to provide a fresh writing sample. So you see, it's not just a passive rule. It's an active evidence-gathering tool for the judge. Let's imagine a very common scenario, the kind you might see on your exam. Suppose a situation comes up involving a check, where the signature on it is being challenged. So picture this. The accused says, "Your Honor, that is not my signature." What can the court do? Well, first, it can take the signature on that check and compare it to the specimen signatures the accused has on file with their bank. But here's the powerful part. Using subsection 2, the judge can look at the accused and say, "Please sign your name on this piece of paper right here, right now," creating a brand new sample for an immediate comparison. This brings us to a really crucial point that you have to remember. Section 72 is what we call a rule of evidence. It's a procedural tool. It's a guide for the court. It is not a penal section. It doesn't create a crime or lay down a punishment. Its only job is to help the court evaluate the evidence in front of it. The words of a law are just that, words. They are brought to life by how our courts interpret them. So now, let's look at two landmark Supreme Court judgments that you absolutely must mention in any answer you write about this section. First up, and probably the most important case on this topic, is Murari Lal versus State of Madhya Pradesh. This case deals with a very basic yet very important question about the court's role in this whole comparison process. So the big question was this: can a judge pretty much act as a handwriting expert and convict someone based only on their own comparison? The Supreme Court said that while the judge definitely has the power to do the comparison, they must be very, very careful. The court said that it's always safer and better to also get the opinion of a handwriting expert to back up the court's own finding. The second key case you need to know is State Delhi Administration versus Pali Ram. This judgment really cements the power given to the court under subsection 2, the one we just talked about. In this case, the question was very direct. Can a court force someone to provide a handwriting sample even if they don't want to? And the Supreme Court made it crystal clear. It confirmed that yes, the court absolutely has this power. This judgment is the solid judicial backing for the court's active role under this section. Okay, let's switch gears for a moment and focus on what this all means for your exams, and also take a quick look at the history of this law. Now, this is a classic prelims question, so pay close attention. This provision isn't brand new. It used to be Section 73 of the old Indian Evidence Act of 1872. Now, under the new Bharatiya Sakshya Adhiniyam 2023, it's been renumbered to Section 72. Please make a note of that change. It's an easy mark to get. So, here are a few targeted tips for your preparation. For your prelims, you can probably expect a direct question about the section number or what it does. For your mains, get ready for either a problem-based question, like the check example we discussed, or a short note on Section 72. And remember, to get top marks, you must mention the principles from both the Murari Lal and Pali Ram cases. All right, we have covered a lot of ground today, so just before we finish up, let's do a super fast revision of the most important points to help you with your last-minute prep. Okay, let's recap. Quick revision के लिए ये चीजें याद रखिए. First, the section number. It's Section 72 of the BSA 2023. Second, the core concept. It's the court's power to compare a disputed writing with a genuine one. Third, the key power. The court can order someone to provide a sample right there in the courtroom. And finally, the two case laws you must know are Murari Lal and Pali Ram. And remember, this is a very high importance section. And that brings us to the end of our detailed session on Section 72. I really hope this has made the provision much clearer for you. For more legal content focused on judiciary, APO, and other law exams, make sure you stay connected with us here at Ganga Education.
Thank you for watching this session. If you found this lecture useful, do like, share, and subscribe to Ganga Education. Keep learning, keep growing, and stay connected for more law lectures.